UNCLOS. The arbitration filed by the Philippines against China was crafted as a maritime dispute about interpretation or application of UNCLOS. In particular, the Philippines sought declarations from the Arbitral Tribunal in respect of three interrelated matters. Number one, China is not entitled to exercise historic rights over the waters, seabed, and subsoil beyond the limits of its entitlements under UNCLOS in areas encompassed within its so-called 9-line. Number two, various maritime features relied on by China as basis upon which to assert its claims in the South China Sea are not islands that generate entitlement to an exclusive economic zone or EEZ or continental shelf, but are rocks within the meaning of UNCLOS Article 1213, or are low tide elevations of submerged banks incapable of generating such entitlements. And number three, China has unlawfully interfered with the exercise of the Philippine sovereign rights and freedoms under UNCLOS and other rules of international law not incompatible with UNCLOS. When we filed our case 3 years ago, the Philippine legal team was hopeful for a favorable ruling, confident that we have a strong case on all issues. The Philippines presented its arguments. We have filed written submissions, which I signed as then agent of the Republic, and later on by Solicitor General Hilbay, who succeeded me in office upon my appointment to the Supreme Court. Solicitor General Hilbay was also privileged to have been among those who presented our case on oral argument before the tribunal in The Hague. Today, the Arbitral Tribunal has issued its award, agreeing with almost all of our 15 submissions. The tribunal found, among others, that, number one, the 9-line is contrary to UNCLOS and has no basis in law. Number two, Scarborough Shoal and 5 other reefs named in our submission are rocks that generate no entitlements to an exclusive economic zone or continental shelf. Number three, Scarborough Shoal has been a traditional fishing ground for fishermen of many nationalities, and that China has unlawfully prevented Filipino fishermen from engaging in traditional fishing in Scarborough Shoal. Number four, Mischief Reef, Second Thomas Shoal, and Reed Bank are submerged at high tide, form part of the exclusive economic zone and continental shelf of the Philippines, and are not overlapped by any possible entitlement of China. Number five, Reed Bank is an entirely submerged reef formation that cannot give rise to maritime entitlements. Number six, China has violated its obligations under UNCLOS to protect and preserve the marine environment. And number seven, China has engaged in the construction of artificial islands, installations, and structures at Mischief Reef without the authorization of the Philippines. With this award, issued by a distinguished panel of impartial legal experts, the rights and obligations of the parties under UNCLOS are now clarified. The award issued pursuant to the compulsory procedure under Section 2 of Part 15 of UNCLOS is binding on China. is binding on China. It has been the consistent view of the legal team that this award will be a potent legal platform as our country moves forward to the political and diplomatic phase of our goal of effectively asserting our maritime entitlements under UNCLOS. From the beginning, and I've always stressed this in my public statements where we explain our case, it has been our view that, and I quote, in the final analysis, the disputes in the South China Sea will have to be resolved diplomatically by agreement between the various states. End of quote. Former Solicitor General Hilbay and I recognize that our goal of securing our maritime entitlements and ultimately our territorial integrity is a process that will take time. However, with this legal advantage, the chief diplomat and architect of our foreign policy, President Rodrigo R. Duterte, can now proceed with the necessary tools at his disposal to get this job done. Thank you very much. Ito aba is part of those features which the tribunal said is not entitled to an exclusive economic zone.
So basically, ito aba is a rock.
Effectively, it's a rock.
So they didn't state it in the law.
Sorry.
They didn't state it in the project. Ito aba is a rock.
I have to read again. I have to read it again.
Instead of modern people, what are options now? I mean, can we take this to another chamber?
The award is final. The award is final.
During that almost all, what did we not get?
We for example, there is during the standoff at Scarborough Shoal, the part of the ruling says that there was no jurisdiction because military ships were involved.
Just this is appealable, or is this appealable, or
No, it's final.
it's final?
Sir, from a legal standpoint, what it should be or what are the next moves that we should do?
As I said, the decision is final, and we would like to stress the next moves will be political and diplomatic.
Sir, there is alleged violation done by China under the UNCLOS. What can be done about it?
Well, the award is a declaration of rights and entitlements. And again, what can be done moving forward is for our policymakers. The options are largely political and diplomatic.
Political and diplomatic, meaning to say justice for both parties in this particular case to sit down, come together, and come up with agreements on issues that they want to.
Well, that will be for our diplomats to think about and proceed accordingly.
China doesn't accept or abide with doing what we've done.
We have always taken the position that we hope that China will abide as a member of the family of nations. And again, that will be a matter for the Philippine government, for our diplomats to meet the challenge of the response of China.
So it will still be under a United Nations mechanism of justice if ever those diplomatic and political avenues are explored, or are we just talking about bilateral ones?
Well, we will not preempt the executive department from getting all of the options.
Did you say that the regulations are illegal?
I'm sorry?
Did you say that the regulations are illegal?
I have to review again on that particular language and regulations.
I know that the Paglas Island is not included to this case, but this award said that none of the Sprat Island create a maritime zone. So do you think that this affect Pagas Island activity, the Philippines activity in the Pagas Island?
The what islands?
The Pagas Island, one of the structure islands the Philippines occupies. I know this is not included, but do you think that this affect the activity in the Pagas?
Well, my response to that is that the decision says what it says, and the conclusions will have to be made.
If none of the island is properties entitled to economic zone, that means you can't claim 200 capital miles say from Pagas.
I'm sorry.
That means we cannot claim 200 EZ from Pagas. The decision says that none of the features in the structure
Yeah, but the Philippines has never claimed those types of entitlements for Pag-asa. Okay, thank you very much because we have to go to another briefing.
Ay, Justice, magandang hapon. Sir, please, lang. Sir, hindi raw po ba yung sabi po ng